Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
All right, Mr. Burks. All right, the state of Michigan versus Desmond Burks, case 24057-24801. Today is the date set for a redetermination hearing. Bond is set intentionally unaffordable. Appearances, please.
Good morning, Your Honor. Mike Glenn for the people. My P number is 77516.
You're on mute, Mr. Reagan.
And Judge, may it please this honorable court, Philip Reagan, P57156 on behalf of Mr. Desmond Burks, who's appearing via Zoom. Your Honor.
All right. Today is the date set for the redetermination hearing. Bond is set intentionally unaffordable. We'll start with Mr. Reagan, sir. Can you tell me, as the bond for your client?
Judge, my client's 33, Judge. He does have some priors, Judge, 2008, 2011. He's in school right now in Dorsey College, working on his certified nursing certificate, Your Honor. In the city has strong ties. The bond was set at $1 million, Your Honor. I mean, this is probably one of the most unfortunate cases I see, Your Honor, where two people are in a situation where there's an accident. They both get out of the vehicle and they both confront each other. And, after that, Judge, my client allegedly hits the complaint and the complaint passes away. I mean, there are other things and other factors, Judge, that are going to come into play. Obviously, this is not charged premeditated. It's a second degree case. It's unfortunate. It's sad. There are going to be other facts that come out. I think that once everything, kind of shoved in face, that my client, was scared. And was shocked. And in fact, I even remember talking to him didn't even realize this gentleman had, passed away. This could very easily have been an assault and battery case, Judge. This assault and battery case turned into a homicide based on the fact that, however, this person, his injuries, person took to these injuries, Judge, person passed away. I mean, the bond is $1 million, Your Honor. It's unfortunate. Again, I'm asking the court to consider something, I guess, a little more reasonable. It wasn't a intentional situation. It wasn't an accidental situation. Probably going to be more like a self-defense situation once all the facts come out and you hear and everybody hears what happened. So I'm asking the court to look at this case, look at the facts. It's a little unusual, Judge, but I'm asking the court to use the bond as something more reasonable.
Excuse me, Judge.
All right. I'm sorry. Let me try to find which one is making the noise, Ms. Fields.
Okay, thank you.
Okay, Mr. Glenn Esteban.
Yes, Judge. I think, Your Honor, so Mr. Vincent and the court at the arraignment on the warrant, I thought made an excellent record as to why the bond was set appropriately at $1 million cash. I don't have to rehash the standard. The court is well aware that MCR 6.106, which governs pretrial release of people that are charged with criminal offenses in Michigan, that if you're charged with murder and or treason, the court can go a step further and remand the defendant. That's not what happened in this particular case. The bond was set at $1 million cash. One of the things the court has to look at is the strength of the case and the likelihood of conviction. When you look at the strength of the case, the fact of the matter is, Judge, is that this particular incident was caught on surveillance video from a gas station across the street. This happened in broad daylight. The defendant in his car is in front of the victim in his car. The victim gently.
Mr. Glenn, I'm sorry to cut you off. And, I know the facts of the case, sir. I see there's a conviction in 2011 for aggravated assault. Are there any other assaultive convictions or any
There is,
other
Judge.
assaultive history with Mr.
Yes, Judge.
All right. Can you tell me what the other assaultive conviction was?
Absolutely, Judge. There was an arson of a home back in 2011, which sent the defendant to prison until 2022. Since he was released on bond.
Mr. Glenn, that's
Okay.
what I needed to know. I wanted to make sure that arson was a conviction. All right, at this point, understanding the facts of this case, and I agree with Mr. Reagan, this is a horrible tragedy, which starts as an assault, and there was nothing to indicate that there were any weapons involved or anything of that nature. But here we have a situation where there's an assault that takes place after an accident, and you have a victim that winds up deceased. This is a horrible tragedy. And I have a defendant with 2 assaultive convictions within the last 20 years charged with murder. This is a matter that a bond does not have to be set, but Judge Ramsey Heap did, and I would note that there is some debate whether first degree or second degree murder counts as that for the point of remand, but the fact that there are 2 assaultive convictions takes the guess out of it. This is a matter that is appropriate for a remand. Judge Ramsey Heap did not, but I also believe that there's a strong likelihood of conviction with surveillance of this information, as well as information from the flock system. So I am going to keep the bond where it's at $1 million cash. The next date is going to be before Judge King on May 24th, 2024.
Judge, I thank you so much, Judge. And just to make a quick record, Judge, and I have so much respect for Mr. Glenn as well as this court, Judge, but I just always disagree with that analysis about the strong likelihood of conviction. I think that, when you're talking about bond, I think, that should not necessarily come into play, only because one, look at something on paper.
Well,
Judge.
Mr. Reagan, to stop you, that's what the statute says.
Well,
that's what I have to go by.
Well, Judge, I understand that. I just disagree with the analysis of the strong likelihood of conviction, because we have one side, Judge. We have one side. We haven't seen the other side yet. We haven't heard the other side.
We have one side, and that's all I have to go on. But,
Okay.
The alternative is I cannot use that analysis and remand the defendant based on the 2 convictions and the charge. So I try to do the thing that gives the Mr. Burks the most chances of getting out. But in this case, I don't have that.
I understand.
This is a clear case where an intentional unaffordable bond is necessary. So this case is concluded.
Thank you.
Thank you, Judge. Have a great day, everyone.
All right, Mr. Christian, can you hear me?
Yes, sir.
All right, this is State of Michigan versus Ronald Christian, case 24055-65801. Today is the date set for a bond redetermination hearing. Appearances, please.
Thanks, Judge Steve Benson for the people.
I'm breaking on behalf of Mr. Christian, Your Honor.
All right, Mr. Christian, sir, could you state your name for the record, please?
My name is Ronald Christian.
All right, thank you, sir. Today is the date set for redetermination. Bond is set intentionally unaffordable. Mr. Reagan has the bond.
Judge, I was trying to really understand this case, Judge, because I look at it, it's a case from November of 2023, but it wasn't charged until February of 24. Now, Mr. Christian was on probation, Judge, for a drug case. Then he ended up going before Judge Cox. He violated in January. he violated the probation in January, Judge, but yet this case still didn't exist. This case somehow came about. He was in jail for 6 months, Judge. Nothing never came about this case. In fact, it's my understanding, complaining witness went down to Investigator Rice, tried to drop the charges, admitted there was no gun ever in the situation. But I just don't understand what took so long. He was already in jail. They waited right before he was going to be done with whatever and brought this case and brought him for arraignment the other day. It just, I don't know. It's my understanding that she doesn't want to go forward. It's going to probably be dropped from November. I'm asking the court to reduce it 50,000, 10%, Judge. I think is excessive. I'm asking the court for a personal bond in this particular matter. I'm looking at the timing, I'm listening to it, and a lot of times, Judge, I'm glad I get the benefit to hear a complete picture instead of just reading part of something and looking at, the hearsay document. Knowing that what the complaining witness's intentions are now, knowing that this wasn't even filed back in November, or it wasn't signed until February. Just, it tells me a lot too sometimes. So I'm asking the judge for a reduction to a personal bond on behalf of Mr. Christian.
All right, Mr. Vincent.
Now, Judge, just based on what Mr. Reagan always likes to say, there are always two sides to the story. Let me give you the other side of the story, which is really interesting because it contradicts almost everything Mr. Reagan just had to say.
Of course it does.
The complaining witness has been contacting the Wayne County Prosecutor's Office, finding out why this case hasn't been prosecuted. She actually just recently, just a few days ago, ended up telling the prosecutor that this defendant continues to try to call her from the jail, which she doesn't want to have any association with whatsoever. And in fact, contrary to what Mr. Reagan said, probably based on what the defendant ended up telling him, she does want to prosecute. And this is coming from interviews that she had with the assistant prosecuting attorney regarding this case. Now, Judge, in addition to the fact that this is being charged as the FA, the UVA, the FIP, I just want Your Honor to have this information as well. So we have the domestic violence, and the complaining witness doesn't have any domestic violence convictions. But we have the domestic violence conviction out of Southfield regarding this defendant in May of 18. We have the domestic violence out of Redford in January of 20. We have, misdemeanor R&O. And yes, Mr. Reagan's right. He's still on probation for a drug charge. But interestingly enough, what you don't know is, Judge, in Florida, this should actually be a DV4, possibly a DV5, because he was convicted in Florida of domestic battery. On top of that, he was convicted in Florida of felony robbery, first degree. So this defendant does have a significant assaultive past. Complaining witness doesn't. Complaining witness wants to prosecute this defendant, contrary to what's been said in the record. So respectfully, Judge, we're asking you to increase this. This defendant allegedly pistol whipped this complaining witness, all because she wanted to break up with him. Smart move, at least the way I see it. Unfortunately, though, she ended up getting assaulted for that multiple times in the face and then pistol whipped in the face, where she actually had to go to the hospital and be admitted for her injuries. We don't think 5,000 is enough, Judge. We're going to ask you to increase it.
All right. I've had a chance to hear both. I'm sorry, Mr. Reagan. I had a chance to hear both arguments. And, both of you got two completely different stories.
Completely.
But this is what I see in front of me. I've got an assault from November of 2023. And I'm looking at what Judge Cox did on the felony matter before him, which I believe pled to less than 25 grams. And I'm looking at the remand order from February 7th, 2024, which I believe is around the same time that this matter was charged. And on that matter, there is a remand for his matter, which was on probation, and it lists the complaining witness associated with our case on that remand order from from February 2024, and they extended the probation to July of 2024. Looks like there was violation hearing held, sentence on March 22nd, and that's the end of this with the revocation of the 7411. Now, what I have before me is a case that was not signed until I would say not signed until 3 months after the incident, and I have an arraignment that allegedly that's happening another 3 months after that, when everybody involved knew that this defendant was here under probation. There we had no indication that Mr. Christian missed any of his court dates. It's my understanding that Judge Cox understands the situation between him and the complaining witness as well. And I have an assault that, quite frankly, you're arguing about when this matter was charged and when this matter was issued. I don't understand why the people are taking so long to have this case come up if it's that serious. I shouldn't say if it's that serious. Flat out, why are the people taking this long to sign this warrant? That being said, I've got no incidents between the complainant and the defendant in between these times that have not been addressed by Judge Cox. I'm going to issue a 5,000, strike that. What is bond set right now?
5,000 cash, 50,000, 10%.
We're going to change this to 50,000 personal, and I'm going to add a tether because they're a Florida, because this matter, the defendant has Florida ties, and we want to make sure that he's here while this matter is pending. No contact with the complaining witness while this matter is pending as well. Mr. Christian, your next date is going to be before Judge Sabri on. Actually, I don't know why this is not before Judge King.
Or Cox.
We have the next date set for May 24th before Judge Sabri.
Judge Mack?
Yeah.
In February of this year, the complaining witness contacted the prosecutor's office talking about what you were just saying. It's not the complaining witness's fault.
No, it's the people's fault.
Right.
Why are the people waiting 6 months to file an assault case?
Well, why though? She ended up getting admitted to the hospital as a direct result of these alleged.
Why are the people taking 6 months on an assault case?
But why are we punishing then the complaining witness, allowing this?
Why? No, stop. This matter is over. We're not going to go through this and argue why the complaining witness is being punished. We don't punish complaining witnesses. This matter is to see if this person is eligible to be released on a bond. This has nothing to do with the complaining witness outside of her safety. Judge Cox remanded this defendant based on these allegations, what the people didn't do. So I'm not about to sit here and argue why the people get another shot at, locking this person up when they didn't do what they were supposed to do in November. This matter is concluded, Mr. Vincent, and we're not going further on this matter.
Okay, all right. I just wanted, Judge.
No, I get it.
Because I'm not the one.
I get it. That concludes this hearing.
I appreciate it.
All right, State of Michigan versus Daquan Hall, case 24056888901. Today is the date set for a redetermination hearing. Appearances, please.
Thank you, Judge. Good morning. Steve Benson for the people.
Your Honor, we'll bring it on behalf of Mr. Hall.
All right, today is the date set for a redetermination hearing. Bond is set intentionally unaffordable. Mr. Reagan as to bond.
Judge, my client's 45 years of age, Judge, has 1, 2, 3, 4, 5, 6 kids that he takes care of, Judge. Actually, he's disabled right now, Judge. I do want to point out, Judge, he is on probation for CCW. I do want to put that out there. He's been doing good on probation. Judge, and he's been living his life, Judge. Quite frankly, he was horrified when these charges came up and were charged. I guess this is a cold case type situation from 2000. He says he remembers the case. He remembers the person, remembers the situation, never forced anybody to do anything. It was absolutely consensual. Came to his house, but she got upset, Judge, when was told she had to leave the house. And she was in a situation where her parents were going to be upset. She got home, parents got upset, made some statements to her parents, Judge, to stay out of trouble. But the biggest thing I remember is that, there was a lot of inconsistencies in her statements. And that's going to be, I think, the biggest thing once this comes up. And when you see this inconsistencies in the statements, it's going to bring some question, Judge. And we're talking about, I guess, these kits that they've started to find and these kits that they've tested years later. But my client, Judge, has been living his life, does have the CCWs on probation for. I do want to be honest about that. Has a bunch of medical conditions. But I'm asking the court, Judge, I think that a personal bond in this case could suffice while this case is matriculating. The case is not going anywhere until it goes somewhere, Judge. But my client has been living life, having children, and I'm asking, I think the court could reduce this to a personal bond, and that will suffice in this particular case, Judge, based on the information that I read and the information that I saw, Your Honor.
All right, Mr. Vincent.
Judge, the defendant has almost as many prior convictions as kids. He's got 5. Ironically, Judge, allegedly at the time of this offense, October 21st of 2000, he was on probation for attempted felony firearm. And Judge, now 20-some years later, he's on probation in front of us for another gun charge. And then in this particular matter, Judge, we have a 16-year-old who allegedly was forced to have sex with this individual. We have a rape kit that and I do have to mention this, Judge, with the help of the National Institute of Justice, that rape kit was ultimately processed and analyzed. But in this particular instance, while allegedly he's on probation for the attempted felony firearm, while presently he's on probation for the CCW, allegedly, and this kind of makes it a little bit more believable, he pulls out a gun and threatens her and makes her take off her clothes and then rapes her. And she's 16 at the time. So we have the DNA, Judge. We have the ID of this defendant as the offender. We have all the priors. Complaining witness doesn't have the priors.
I've never heard
25,000, 250,000, 10%. We're asking you to continue it.
One moment.
Firearm, man.
I'm sorry. 1 second. I think I got the wrong case here. So I'm reading the investigator's report, and it indicates that there was a kit first tested by the police lab in 2000, where at least there was a possible male DNA result on that date. Then in 2014, MSP receives the lab, and there's a CODIS hit at that time. In 2014. Not only are these serious allegations, but there are there is a lot of evidence in this matter, even though it's from 2000. The date of the offense is 2000. However, I don't believe that there is an inherent danger while this matter is pending until there's an actual conviction. So what I'm going to do is amend this to $250,000 personal with a GPS tether house arrest while this matter is pending. Mr. Reagan, is your client working right now?
Judge, he's on disability right now. He was in an accident. He has a lot of different, he has a shoulder replacement. The answer is no. Let me just say no.
All right, then that's where we're at. 250,000 personal GPS tether house arrest.
Thank you, Adam.
Thank you, Judge. I'm done.